Are you married to a U.S. citizen or a green card holder and planning to apply for a marriage-based green card? If so, stop right here, because what you're about to hear could determine whether your application is approved, denied, or even land you in deportation proceedings. Since President Trump returned to office in 2025, U.S. immigration rules have undergone some of the strictest changes we've ever seen, and marriage-based cases are now under the heaviest scrutiny. These are not rumors. These are real policies already affecting thousands of couples across America. For decades, marriage to a U.S. citizen has been one of the most direct and secure pathways to permanent residency. A citizen could file Form I-130 to sponsor their spouse, and in many cases, the process was straightforward. Even green card holders could petition for their spouses, although the wait was longer. But 2025 has turned this system upside down. The administration has ordered immigration officials to treat marriage cases as high risk for fraud. Instead of assuming your relationship is genuine, officers now begin with the assumption of fraud unless you can prove otherwise. One of the biggest shifts this year is the fraud detection protocol inside USCIS. Officers no longer rely only on your submitted forms. They now use a mandatory checklist that covers nearly every aspect of your personal life. Your entire immigration history is reviewed, your travel records checked, your living arrangements verified, and yes, your social media profiles are cross-examined. If the timeline of your relationship doesn't line up, if you don't have joint finances, if you married soon after overstaying a visa, or if there are gaps in your story, your case can be flagged for deeper investigation or denial. This is a huge change. In the past, officers often gave couples the benefit of the doubt. Now, they assume dishonesty until you prove otherwise. Another alarming update is the risk of deportation even while your case is pending. Before 2025, spouses of U.S. citizens were generally safe from removal while waiting for their green card, unless they had a serious criminal history. But under new rules, filing an application no longer shields you. If you overstayed a visa, submitted an incomplete form, or left out key documents, you could be placed directly into removal proceedings, despite being legally married to a U.S. citizen. This means thousands of people who once felt safe after filing are now living under the shadow of deportation. The paperwork itself has also changed. In early 2025, USCIS quietly updated key forms like the I-130, I-485, and I-129F without making much public announcement. These new additions include more background questions, stronger fraud warnings, and expanded sections on immigration history. If you use an outdated version, your application will be rejected automatically. Many couples have already lost months of progress simply because they filed the wrong edition. Always check the bottom of the form for the edition date and confirm it matches the USCIS website before you file. Interviews have become much more aggressive as well. Stokes interviews, once relatively rare, are now standard in many cases. In these interviews, each spouse is questioned separately for an hour or more. Officers may ask everything from what side of the bed you sleep on to what you had for dinner 3 nights ago. They compare your answers line by line, looking for inconsistencies. Even genuine couples can stumble under this kind of pressure, especially if they've been long distance or come from different cultural backgrounds. And in 2025, small inconsistencies are being treated as red flags.
Visa overstays, which were once forgiven more easily in marriage cases, now carry much harsher penalties. Overstays of more than 180 days can trigger a 3-year re-entry bar, and overstays of more than 1 year can lead to a 10-year bar. These punishments apply even if you are married to a U.S. citizen. The only way around them is through a hardship waiver. But here, too, the rules have changed. USCIS now requires proof of extreme hardship with heavy documentation. Simple financial statements or emotional letters are no longer enough. Officers are looking for severe, life-altering consequences, such as a serious medical condition, documented psychological trauma, or proof that the U.S. spouse would face unbearable harm without their partner. These waivers have always been challenging, but in 2025, they are significantly harder to win. Perhaps the most frightening part of these changes is what happens if USCIS accuses you of marriage fraud. The consequences are devastating. A fraud finding results in a permanent lifetime ban from U.S. immigration benefits. You can never apply again, regardless of future circumstances. On top of that, there are possible criminal charges carrying up to 5 years in prison and fines up to $250,000. And the sad truth is, even real couples can be caught in this net if they fail to provide enough evidence or make mistakes during the process. Now, some lawmakers are pushing back against these policies. Bills like the Dignity Act of 2025 and the American Families United Act have been introduced in Congress. These proposals would shorten wait times, create dual intent visas for spouses, and give judges more power to stop deportations that separate U.S. citizens from their loved ones. But as of now, none of these bills have passed. That means the stricter rules remain in full effect, and couples must prepare accordingly. So what does all this mean for you if you're applying for a green card through marriage in 2025? It means preparation is everything. First, make sure you are using the latest forms directly from the USCIS website. Double-check the edition date before you file anything. Second, gather as much joint evidence as you can. This means bank statements, utility bills, leases, health insurance policies, photos from different times and places, travel itineraries, even affidavits from friends and family who know your relationship is real. The more you can show that your lives are truly intertwined, the better. Third, prepare for the interview process. Talk with your spouse about the details of your daily life so you're on the same page. Remember that officers aren't just testing your memory, they're testing whether your answers align consistently. Finally, if you have any complicated history, such as visa overstays, previous denials, or time out of status, consider working with an experienced immigration attorney. In 2025, the risks are simply too high to go it alone. The reality is that marriage-based immigration, once considered the safest and most secure path, has become one of the toughest. The Trump administration's changes are reshaping the system in ways that put even genuine couples under suspicion. But if you stay informed, stay prepared, and approach the process with honesty and thorough documentation, you can still succeed. Don't take shortcuts. Don't rely on outdated information, and don't assume marriage is a guaranteed ticket to a green card. That era is over. If this video helped you understand the reality of marriage-based immigration in 2025, make sure you hit that like button, subscribe for more updates, and share this video with anyone who might be going through the process. The more informed you are, the stronger your chances of success. Marriage can still lead to a green card, but only if you approach it with preparation, strategy, and the awareness that the rules have changed dramatically. Stay safe, stay informed, and I'll see you in the next update.